Okay, I have just started recording the session, and since it's now 3, I do want to welcome everyone and thank you all for joining us, and thanks for your patience, and thanks for signing in early to make sure everything's working. It's really great. I'm Sue Osthoff. I'm with the National Clearinghouse for the Defense of Battered Women, which is located in hot Philadelphia, hot and humid Philadelphia, and I'll be one of your hosts for today's webinar. And Kirsten Faisal, who's our legal coordinator, she'll be the other one. And as many of you know, we have to go over a few logistics, particularly for some new people, and we know we have some people who have not participated before, so we do want to give them the tech information in case they have any problems. If you're disconnected from the webinar at any time, just go back to that original email, the one you got early this morning, and click on the link and log back in. Make sure you log all the way out and then log back in. And if you have any problems getting back on, just call iLink support at 800-799-4510, and Dot put that in the chat box. I also want to thank our assistant for today's webinar, Dot Goldberger, who just put that number in there. And so in there is in the chat box, which is in that lower left-hand corner. So some of you already did this, but if you wouldn't mind doing it again, if you would let us know where you're calling from. And the other thing, your name will come up if you're signed into your own email. And so we don't need your name, but just if you can say where you're calling from. And if there's more than one of you at your site, if you can let us know how many, that's really helpful, because we know sometimes groups of people actually call in together. As I think you figured out, all the participants are muted, so we're going to be using that chat box for questions, any problems, or any comments you have. And we will, as we always do, be collecting questions during the webinar, and time allowing, we will pose as many as we can to the presenters at the end of their presentation. And if you're joining us by phone today and you have any questions, please email Dot at dot@ncdbw.org. As I mentioned, we are recording the webinar today, and you'll be able to access this on our website, which is www.ncdbw.org, in about a week. We've also posted today's PowerPoint in a version that you can save or print, and the presenter's bio on the Google Drive, and you got that link in the reminder notice this morning, and Dot will post it again in the chat box. And if you're signed into the iLink and you're seeing the PowerPoint now, you do not need to go and get that now. That's only if you want to save it later. After we're done with the webinar, and when you sign out, you'll get a little email message that has a very quick little evaluation, a little survey. And if you could take a minute or two to fill that out, it's really helpful. That will also come to you in an email about a half an hour after the webinar. And in that, it will say that, yeah, you attended the webinar, and that will be your confirmation of participation. So what we want to do now, actually, is go and learn a little bit more about who is on the webinar. And what we want you to do is actually, Cindina, are you seeing the questions?
Yes, I am.
Okay, because I know there's a delay sometimes. So you see there it says, how would you describe your profession? And then there's a dot, and it says community-based advocate, coalition step. Go right up, click, for those of you who are participating on the actual webinar service, click right on the dots there. And if you click other, then if you could go down to the chat box and tell us what your profession is, if it's not otherwise listed, that would be terrific. And Cindine, are you seeing the results?
I sure am.
Okay, so you're getting a sense of who's on the webinar. I mean, you see it does not add up to 100% because it is looking at the 58 people who are on, and not everybody has answered. So if you could answer, it's really helpful. I mean, right now you can see that we have about 27, about a third of the people are community-based advocates or coalition staff or other national TA providers. So if you click other there, if you could go over and tell us in the chat box what your profession is that's not otherwise listed. And right now this is saying we only have 2% that have participated as an expert witness, and many have not. And then thank you for answering if you're an OVW grantee, and if so, what kind. So I'll just give that another couple seconds.
And it looks like some people are having...
The dots aren't working?
Yeah.
Inactive dots. Huh. Well, for some of them it's working. So if your buttons aren't working, just go ahead and you can put it in the chat box there. But if it's okay if you're not able to give us that information. I think we're getting a sense there of who is already on. Okay, and Dot, I hope you've had a chance to get those answers. And we will collect the answers in the chat box, Tim and Kirsten, and so that you can have access to those. Okay, so I just want to thank you for helping us know who's on the webinar, and thank you for participating today. For those of you who just joined, a couple new people here, I'm Sue Osthoff with the National Clearinghouse for the Defense of Battered Women, and I really want to extend a very warm welcome to all of you, and thank you for joining us in this webinar, which is actually the 9th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you missed any of the other earlier webinars in this series or in our reentry series, you can get the recording, and which pulls up the PowerPoint from our website. So all of the past ones are on our website, which is ncdbw.org. As I said earlier, all of the participants are muted, so we're going to collect questions down in the chat box and during the presentation. And time allowing, we'll pose as many of them to our presenters as possible. So just before I turn this over to Sandine, I do want to thank the Office on Violence Against Women for the support of this project on expert witnesses. We just think it's really great that they're supporting work about expert witnessing. So many thanks to OVW. So as you're probably aware, today's webinar is titled Working Together, What Attorneys and Domestic Violence and Sexual Assault Experts Can and Should Expect from One Another. So without further ado, I want to pass the virtual mic over to Kirsten Faisal, who's our legal coordinator here and who's coordinating our expert witness project, and she'll introduce today's speaker.
Thank you, Sue. I'm really happy to have the opportunity to introduce these two folks to you all today. I'm going to keep this brief, but I really do encourage you to take a look at their full bios. You can see them on the screen in front of you in teeny tiny print, or you can go to that Google Docs page that was linked in the email that you got today and take a look at a more readable document. So briefly, Kirsten Faisal has been the Director of Training and Technical Assistance for the Iowa Coalition Against Domestic Violence since 1995. She's also on the steering committee for the Batters Education Program for the Iowa Department of Corrections. She's trained for the Iowa Law Enforcement Academy and the Department of Human Services. She's also served as chair for the Iowa Domestic Abuse Death Review Team. She's provided expert witness testimony as well in both civil and criminal domestic abuse cases. I've learned a ton from her over the last couple years, and I'm really glad that she's here to talk with us all today. Tim Gruenke is the district attorney in La Crosse County, Wisconsin. He has been a prosecutor for 19 years, and he has prosecuted all kinds of cases, including homicide, but he does specialize in sexual assault and other sensitive crimes. He has trained a wide variety of professionals, which is how I met him in Appleton, Wisconsin a couple of years ago. In 2013, he was recognized as District Attorney of the Year by Wisconsin prosecutors, and in 2008, he earned the Voices of Courage Award from the Wisconsin Coalition Against Sexual Assault. Thank you so much, Kirsten and Tim, for all your great work and for your willingness to share your knowledge with all of us here today. And with that, I will turn it over to you two.
Thank you.
All right, thanks.
Take the floor, Tim.
I will. As a little bit of further background, I think I'll just explain by saying that as you can see, I've been a career prosecutor, so most of my information comes from the viewpoint of a prosecutor in criminal cases. And so that's been my expertise. I don't have a lot of expertise in civil cases, so just so you know where I'm coming from. And also I was, as a younger prosecutor, was thrown into the sexual assault arena and learned a lot from the advocates and SANE nurses in my community. And so I'm always willing to kind of give back a little bit and help maybe learn from my mistakes, how I learned as a prosecutor, how we worked well together in lacrosse, and hopefully some of this knowledge will be helpful to you. I'm going to do a little bit of background information on how we even use expert witnesses and then turn it over to Kirsten to give a few more of the nuts and bolts. But first, maybe an obvious question, if you haven't done this before, if you haven't testified before, why do we even need to use expert witnesses? Well, in sexual assault and domestic violence cases, the prosecutor is fighting an uphill battle compared to other types of cases. If I'm prosecuting a burglary or an arson or even a homicide, usually the jury wants to convict those people, and they're willing to believe in the victims and believe in the police. But when we talk about sexual assault cases and domestic violence cases, the scale's tipped a little bit. Jurors need something usually a little bit more to disbelieve what we're telling them. And in my experience, adult female victims have a tougher time with juries and their credibility than other witnesses. And I think why that is might be a whole another webinar, but basically when I walk into court and talk about a victim of a crime as a burglary or even a child sexual assault victim, if I just give them the evidence, they're ready to convict. They're ready to believe. If I talk to them about a college girl who was raped after going out to a bar with a guy, or an acquaintance that was raping a woman after she'd been drinking alcohol or using drugs, the jury's not so ready to believe. They need a lot more information. They want to hear a lot more from the state before convicting. And the dynamics of sexual assault and domestic violence cases are not intuitive. You all know this if you work in this area. But for jurors who have never thought about these topics, they don't understand these concepts of why a victim might not report right away, why a domestic violence victim might go back to their abuser. These aren't normal everyday things that people just know. And so we want to use expert witnesses to help us explain to the jury why these things happen. And even some police, prosecutors, judges have a hard time understanding these topics. As a prosecutor, we shouldn't try to make the victims just prove the case on their own. Victims won't believe a victim just because they say so, and most victims don't understand their own actions, especially in sexual assault cases. They will blame themselves, not understand why they didn't fight back, why they didn't scream. They maybe always believe that they would if this ever happened to them. So they're not able to be articulate enough and sophisticated enough to explain to the jury why they did what they did or why they didn't do what they didn't do. And so an expert witness, which is usually somebody who's either a therapist, counselor, crisis center worker, SANE nurse, they're somebody who can give the jury the framework to understand the victim's testimony or the medical evidence. Having victims do it on their own is usually not very successful because they're not going to be able to explain their own actions very well. Some other reasons why we might want to use experts is it educates the jury and the community on these topics. I think in the area of domestic violence we've come a long way. At least in La Crosse, Wisconsin, many trials we don't even need experts anymore. Juries can kind of understand why a victim might go back to the abuser, why domestic violence happens. But in sexual assault cases, I think we're still kind of in the dark ages. I think that a lot of people still don't understand sexual assault dynamics, don't understand why it happens. And so I still think we're in that process of educating people and hopefully making a difference so that someday we'll be at the place we are with maybe domestic violence cases. Helping train experts like all of you, helping use experts educates prosecutors like me to better understand victims and do better in their cases. Even prosecutors who've been around for a while, you all know there's a difference between 10 years of experience and 1 year of experience 10 times. Many prosecutors will have prosecuted burglary cases, drug cases, but these cases are different. And using experts and in your community, helping prosecutors use experts helps train those prosecutors better. It also educates the judges for future cases. If judges aren't understanding these dynamics, if they're new to the bench, haven't done criminal trials, it may help them understand some of the dynamics that, again, aren't intuitive and aren't the kind of things that they teach you in law school. And I want to stress one thing here in this webinar, that there are certain things that we can't expect from an expert. You can't turn a bad case into a perfect case. And I think sometimes people are relieved to hear that. Attorneys should not expect the expert to come in and save the day and say, I've got a really bad case, it's really difficult, it's going to be a hard case to prove. The burden is not on the expert to prove that case. You can smooth off the rough edges, but you shouldn't be expecting the expert to fix every problem with the case and turn a bad case into a good one. That's unrealistic. An expert also can't change the reality of the evidence, can't ignore things that are harmful, can't change what the victim's testimony really is. By using experts, what we're trying to do is just make sure that if the jury's going to vote not guilty, it's because of the evidence and because of the presentation, and it isn't because of some of the myths about sexual assaults or domestic violence that they might otherwise be resting their decisions on. In some possible areas of expert testimony, I wanted to go over this because I think sometimes people feel like there's nothing that I can offer to the state. Prosecutors ask me to be an expert witness. I'm not sure there's much that I have to say, but you actually have quite a bit to say. There's really an infinite number of areas that experts can talk about, but some of the most common are delayed reporting to the police of a sexual assault, explaining to the jury why that might be normal, why that might be expected, or not surprising in our line of work. The lack of physical resistance or lack of screaming or not saying no during a sexual assault. The lack of physical injuries, which usually comes from a sane nurse. Post-assault behavior in domestic violence or sexual assault, such as returning to the offender. Making inconsistent statements to the police due to the trauma that they've gone through. Same reason, the lack of memory of details. And in domestic abuse cases, not leaving an abuser despite repeated offenses. Many of the things, while these might be basic to people who work in the system and might seem to be common sense, might seem to make perfect sense. Again, if a juror has never had any experience with working in this area, never experienced with living in this area, these are things they're not going to automatically know. Another reason why we want to use experts in this area is many times prosecutors have made the mistake of presenting a trial in the wrong way and presenting victims and experts in terms of believe the victim's telling the truth, here's the victim's story. And I just have a brief story that's not in the PowerPoint that isn't an original, but I think it illustrates a point why we want to use experts. If I told you a story about a woman who died in a car accident, and I told you that she'd left work early that day, which is unusual for her, she took a different route home because it was a nice day out and it was a nice day for a drive. As she was driving along, she was changing a CD in her car stereo. The light was about to change and she went through the light that was changing yellow, got hit by a drunk driver and died. If you were at that funeral and you said, how could we have stopped that from happening, you'd have examined everything that she did. If she hadn't gone early that day, if she hadn't taken a different route home, if only those things hadn't happened, she would not have died. If I told you that same story from a different perspective, an offender is at a party, young man, underage, drinking alcohol, doing cocaine, gets into a fight, tries to leave the party, his friends try to stop him, he leaves anyways, steals a car, speeding down the highway and goes through a red light and hits that woman and kills her. Now you're saying, how could we have stopped that from happening? Well, if he hadn't been driving drunk, if he hadn't stolen the car, if he hadn't been speeding, if he hadn't gone through the red light. And when we get to sexual assault and domestic violence cases, I think too many of us use experts in victims in the first scenario. We say, this is the victim, she's a good person, you should believe her. We then use the expert to say, here's why you should believe her. We never talk about the offender. So when we use experts, we just have to be careful not to go too far into just focusing on the victim and the victim's behavior. So while it's important to use the expert and use the expert in these different areas, it's also important not to overuse them or rely on them too much, because you run the risk of an opening statement talking about the victim and your expert, the defense attorney then in their opening statement talks about the victim and what she did or didn't do. And at the end of the case, all the jury's hearing is all about the victim and what she should have done or should not have done. And that leads to problems instead of focusing on the offender. So it's one way of turning the cases around a little bit that most prosecutors aren't used to doing, in a way that focuses on the offender and not on the victim. And there's two general ways to use an expert at trial, and after this I'll turn it over to Kirsten to kind of give some more nuts and bolts of how this might work. But the first way to use an expert at trial is, I think, the way that Kirsten prefers, is that the expert can review the case file, the police reports, maybe medical records, and can compare this victim's behavior to the behavior of known victims. In other words, talk about what this victim did, and then talk about why research says we know that that's normal. Most victims don't report to police right away when they're sexually assaulted. Most domestic violence victims do return to the abuser at least one time. And in this case, that happened, and here's why. So the expert spends time reviewing all that information beforehand, testifies about it, and then compares it to the victim in this case, and how it's relevant, how it's consistent, how it's important. And this approach helps explain this particular victim's actions and their statements, and helps the jury understand those complicated dynamics in that format. Now, the downside to that is time, which many people don't have. It takes time to review that information, takes time to go over it all, takes time to organize it, takes time to make sense out of it. In some jurisdictions, if you're paying for this expert, that might be a downside. Your jurisdiction might not have the money available if you don't have grant funding or nonprofits to be able to pay somebody to do this. And finally, the last downside is maybe, as I said, an exaggerated focus on the facts of that case instead of on the dynamics. And you get tied up in what actually was said, what actually was done, and that sometimes takes away from the point you're trying to make with the expert. The other way you can use an expert, I call expert light. Diet expert didn't seem quite right. But in this way, you can use an expert to just talk about the dynamics of the case and not talk about the particular facts of the case. Just ask questions generally. Why would a woman not report to police right away? Why wouldn't a woman fight back when she's being sexually assaulted? And never talk about the facts of this particular case and what happened here. The advantage is it saves the time, it saves the money, and the expert doesn't get drowned into the confusing fact patterns, maybe multiple police reports, multiple statements, and sometimes in complicated cases, that can be an advantage. The downside is that it may not be as effective because the general description or the general patterns might not be quite present in this particular case, and the testimony loses its appeal if you don't have that kind of connection to the facts of this particular case. But those are the two general ways how I use experts, and both will work, and sometimes the factor of just what kind of case it is, how complicated it is, how much time and money people have to spend on the case. So kind of with that background, I'll turn it over to Kirsten to talk about how the nuts and bolts of this relationship works.
Okay, thank you. Thank you, Tim, for that. That's a great setup for me to pick it up. And thank you, Sue and Sandine and all of your staff for giving us the opportunity to do this. Yeah, I do actually prefer the first route, though I have sometimes testified with very little information indeed. But I kind of like to approach this from, what happens when that first phone call calls in, and as it goes on for me. When I get a phone call from a prosecutor, from an attorney, because I've done both criminal and civil, I'm hoping that they can at first give me a brief overview of the case, that they can, I'm sorry, I've got a phone ring in the background. There we go. That they can give me a brief overview of the case, that they already know what it is that they want to accomplish. Why on earth are they calling me? Sometimes they don't, and that's okay if they're calling just to talk it over and think out loud and brainstorm whether or not this is something that would be helpful to their case. But usually they have a plan, and I want to know what it is. Usually there's some kind of problem, whether it's that the victim has recanted or whatever. Tim gave out a number of them, and so I want to know what's their goal. Why do they need me? Sometimes it is helpful for me to know where the victim stands in all of this. Is the victim wanting this to go forward? Are they not? I like to have an advocate hat on. I'm someone who does like to have case information. I want to know, for my satisfaction, is it actually, in my case, at least because I don't do sexual assault cases, is it really domestic violence? Is it something that I think I could contribute? And not only that, but am I the right expert? Because I have, after hearing from the attorney, I've taken a look at the case and said, well, I said a number of things. One, I don't really think you need me at all, and it really will be muddying the waters and spending way too much time talking about the victim when you have this perfect case where you don't even need to go there. You have enough. I've turned the case down when I said, actually, as I take a look at this, it's your client that's the perp. I don't really think you want me to testify for you. And there's times I've said, yeah, I could do this, but who you really need is so-and-so, and referred them to maybe an expert to just come in and talk about PTSD, somebody who has the expertise to diagnose that and really break that down from that perspective, or a sane nurse who could really talk more procedurally and medically, things that I can't actually do. So that's one reason why I want that case information from them. Typically, police reports, typically depositions, photos. If there's previous assaults, that's helpful. And I'd love it if this initial phone call happened with enough time that I get a chance to review those materials. That is going to vary what does enough mean. Unfortunately, I do get calls where I have this trial that's going this week or next week. Can you do it? And I almost automatically say no, simply because that's just too short notice. And that's, in some ways, that's almost a red flag for me that particular attorney hasn't been thoughtful in developing their overall strategy. And I'm a little concerned that at this point they just are flinging whatever against the wall to see what sticks. So I want at least a couple weeks' notice, if at all possible, so I can look at the case myself and draw my own conclusion about whether or not I have anything to offer. That does leave me a bit more open as far as the drawbacks of using that style. It leaves me a bit more open to, I think, appearing biased. I think it leaves me open to being pushed for a diagnosis or a particular opinion about the case that I can't or I'm not competent to give. So there is a drawback to it. But there you go. That's the way I learned how to do it. That's where my experience has been, and so that's what I prefer. But I certainly understand that there's valid reasons for doing both. What I really, really don't like is when a subpoena arrives, and I have never talked to that particular attorney. I have no idea what the case is about, and I've got to track it down and figure out what's going on. And that has happened sometimes too. Another thing that I want as an expert in that initial conversation is just to get a feeling for myself whether or not that attorney has a basic understanding of domestic violence, where they're at with that, or at least are they willing to learn? Do they want to hear what I have to say? Are they open to me bringing that advocate lens to it and perhaps telling them stuff they don't know? Because sometimes people don't know what they don't know, and I might look at it and have a totally different perspective, and I want to feel like they're open to hearing that. Even things like sometimes it's just little stuff. I can think of one case where it was a strangulation case, and once I said, well, you know, lack of visible strangulation injuries is actually more typical than not. Even in half of the strangulation homicides, there may not be external bruising. That was like, oh, big ta-da moment. So I want to be able to put that out there and actually have it be heard. And sometimes I will say sometimes that process of just education, in one case, it went so far where I was really turning into more of an advocate for the client. This was a civil case that we ended up, I ended up arranging for a separate expert because my role had shifted too far into educator and advocate with that particular attorney. Now the good thing in the end of that one is that the attorney ended up waiving his fees for the client and said she doesn't need to pay for my education, and then offered to do some pro bono cases for us as well. So, hey, that was a good thing. You know, when I said I would like them to have give me some leeway, that's also about respecting my time and my schedule, and being able to shift with me if I say, okay, I really am only available Thursday morning, so if you can make sure that's when my testimony is, that's great, but not expect me to sit in the courthouse all day long and not even call me till the next day, those kinds of things. It's really helpful in that conversation if I get a sense that the attorney understands those things Tim talked about, that here's what I can talk about, here's what I can't, here's where my expertise lies. Don't ask me to, you know, go over there and talk about forensics just because you have me on the stand, and so let's just have her do everything because it's quicker and easier. Well, it's not. That's not a place that I can talk. What the attorney is going to get from me back, they're going to get a copy of my experience, my CV, and usually it's an email. So I'm going to say, yes, I've testified before. I'm going to talk about the kinds of cases and what I've done in those cases. I'm going to send them my CV. I'm going to be very clear about, yes, I'm comfortable talking about this. No, I'm not comfortable talking about that. So I have a case right now which is the charge is sexual assault, but it is an intimate partnership. And so one of the first questions the attorney was asking me is, should I really have a sexual assault expert instead on this, or is this within your realm? And once we talked through it, it's like, no, this is something I'm very comfortable talking about. So just it was helpful to be able to define that. I let them know what I want to see, and I'll let them know what I'm going to cost. And that's really going to depend. Obviously, I like to be reimbursed for my mileage. If it's a case for the state and they are going to have me there for sitting in a hallway waiting to testify for a day, then I expect a little remuneration for that. It doesn't go to me; it goes to my agency anyway. If it's a battered woman and this is a custody case or whatever, I more often than not end up waiving all of that because I feel like that is one of the services my agency provides is this form of advocacy or service. But I want to let them know that up front. Many of the times this is new territory for whoever I'm talking to, and so I do have sample questions for a prosecution case, sample questions for a custody case, sample questions for immigration. I've also testified in probation revocation. So I have some of that I can send. And in the course of the conversation, there may be other things. Often they want a copy of my any exhibits that I'll be using, and so often just right from the very first conversation, I know I'm going to be using the power and control wheel, so I will send them that. As the case kind of progresses, I will want communication on where's the status. Is it dropped? Has it been moved? Has there been another assault that is relevant to what's happening with that case? Has the victim recanted? You name it. I'd like to have whatever information is so I know where it's at. Again, partly that's respecting my time. and partly that lets me think about where I need to push or pull whatever I might be talking about so that it gives the best context. I don't want to be talking about stuff that's not relevant to this particular case because I don't know about you, but I could talk about domestic violence and the dynamics from here to next week. And I really need to find a way, by having information about it, to trim it down to what is going to be most helpful for that judge or jury. So keeping that communication stream open throughout is really helpful to me. If there's particular information that the attorney I'm working with wants to know or plans to ask, either in the deposition or in the trial itself, that helps me to prepare. There may be things like, one thing that I quite often use is Jackie Campbell's lethality assessment, the danger assessment, which some of you may be familiar with. Just as, some people really like numbers and they like studies, and that is one piece of work I'm really familiar with that helps me to convey to either the trier of fact or sometimes to other attorneys just what kind of level of danger this particular victim was in. So I may be sending them information about that, and we may even use that much more formally than just bringing up, well, these are some of the risk factors. If the attorney I'm working with knows the opposing counsel's arguments for the case, that's really a great thing for me to know, any kind of likely strategies or what things they're going to bring up. I'll often hear, well, this, the previous assault or the previous abuse was so long ago, it wasn't reasonable for her to be scared. I've had that one come up a number of times. Just this last week I was deposed, and the element of fear is really important in stalking cases in Iowa, and that was something that the opposing counsel was focusing on. It was trying to lay out that somehow this victim's fear was irrational. I was asking questions, is there such a thing as irrational fear? And I said, well, I have an irrational fear of spiders, but when somebody has repeatedly harmed you in the past, no, I don't think it is irrational to be afraid of them in the future. So that was kind of, because I already knew that was one of the strategies, I could think about how I might answer that. What else? As I said, sometimes I have a perspective that the attorney doesn't necessarily have. And so really, I think one of the things about using an expert is not just an expert for the judge or the jury, but it's the expert as a consultant for that attorney to frame the case for them, to give them sometimes language that they can use, even if they never end up actually calling you to the stand. A case that comes to mind for me was where a young victim she was a runaway. She was like 19, and essentially she'd been picked up and stayed on this farm for a long period of time, and was being abused by the head of the household. But the wife on the farm was also being abused by the head of the household, and there were children on the farm. And basically the stuck point was, why is it that this particular victim stayed? They weren't married. They weren't, yes, they had a relationship here, but they could have walked away. They'd run that far. Why couldn't they just run away farther? And it seemed very clear to me that for her, she had bonded with the other victims in that situation, with the children that she had been made to take care of. And so rather than reframing her as being crazy for staying there, it was a reframe of, look how courageous she was, that she did not want to leave until they could all be safe. So she went from being this strange person they couldn't understand to, oh, she's actually the hero of the case. So that didn't have anything to do with me taking the stand, but it really affected the way the case was presented. Let's see, what else can the prosecutor expect? As I said, they can expect exhibits. I almost always give them the power and control wheel. I don't like to hand out research, and I don't like to talk about research much because anytime you start bringing up research can always be challenged, and anytime you nail yourself down to a particular study, you better be prepared to defend that particular study and to know what its strengths are and what its weaknesses are. So I like to talk about my experience. So if you're going to be going into this, I would memorize the phrase, in my experience, or what I see typically, or this particular behavior is consistent with what I have seen with the majority of clients I've worked with, those kinds of things. So my experience is less open to attack than relying on some study that I read 2 years ago that was done in 1997. So I kind of limit the exhibits, and I'm just talking about myself. You will get, as the case progresses, you'll get interrogatories. In other words, a list of questions that these are the things that any witness, but in this case this particular witness, is going to be talking about, and these are specific questions. So it's kind of a chance for you to write down what it is you'd be testifying, what it is that you would answer, and then of course that goes to the opposing counsel. Depositions, that is the opportunity for them to question. And one thing I'll say is if depositions can be overwhelming because it's an open book, and they can ask you just about any question, and they have asked me whether or not they've asked me about my own abuse history. Have you been victimized by domestic violence? Are you a survivor of sexual assault? They've asked me my marital status. They've asked me if I've had children. They've asked me a lot of things in depositions. But what I can say is, since that's the place that the opposing counsel tries out their strategies and their theories of the case, often if the deposition goes well, that's the end of the case. If they know that, okay, the prosecutor is there and prepared to handle recantation, the prosecutor is there and ready to handle the why she stayed, often then there is a settlement. Oops, and I just was tossed out of the session. Can you still hear me?
We can still hear you.
Okay, well, I'm going to sign back into the webinar, and I'm going to keep talking based on the notes in front of me. So there you go. Affidavits, sometimes, particularly in the immigration cases, it has been, a lot of it has been writing an affidavit as an expert. How does battering for immigrant women, how does that differ? What are the specific barriers? Sometimes during the deposition, the opposing counsel asks for specific things. I had one person ask me for what exactly my bibliography was for every piece of research and book I had ever read. And I wanted to say, you've got to be joking. But instead, I went back and I put together, I selected bibliography of the things I was most familiar with. And here's another thing. I did send it on to my attorney, but really that turned out to be just more of a strategy to try and scare me in the deposition, and he didn't really want it, and it didn't go any farther. But those are the kinds of things that that the attorney working with you can expect from you and that you need to be prepared to do. And to do it in a timely way, because you might not have deadlines for these cases, but your prosecutor does, and they need to have a date that they're submitting, who's going to be their expert. They have dates where they've got to submit all of this stuff so that the opposing counsel has a chance to review it and respond. So that's kind of that professional level of, yep, I've got it, I'm on it, here it is really important, and the least you can do. And with that, that's a good place for me to try and sign in again and turn it over to Tim.
Okay, thanks. And after hearing some of your experiences, Kristen, I think I should apologize on behalf of all attorneys for our behavior and treatment of you, because some of that sounds awful.
Well, one of the things I was going to say is I also, at trial and later, one of my expectations is that the attorney that I'm working with steps in and protects me from some of those things. Some of those egregious stuff, that to me is one of their roles, is to say, you know what, her personal history isn't relevant.
Yeah, hopefully they do that. And that's, prosecutors do and attorneys do need to step in and protect their witnesses. And I think probably a lesson for everybody listening, if you're wanting to be an expert witness, I think Kirsten gives some really good practical advice on being clear and upfront with your expectations, because many prosecutors, as I mentioned, aren't going to know exactly how you do your job and what you're expecting, and might assume you know how to testify, and they might assume you've done it before, and you need to make it clear that if you're new to it, you need to train them. Prosecutors can sometimes be like puppies. They're wonderful companions, but they have to be trained, and you need to stay on top of them. So good advice. I'm going to talk a little bit about how it works at trial and some of the questions about just basic how we testify, some things to look out for, some things that work well, don't work so well. The trial is more of a presentation of a training rather than a formal question-answer technique. It's not a fact witness like, what did you see, what did you do next, what did you say? It's more about introducing the expert, usually introducing their experience, maybe their background, training, education, and then educating the jury about some of these topics. So it's a little bit more of a presentation than it is just a question and answer format. And that's where using a PowerPoint or other type of exhibits helps, so that the jury will learn from reading a PowerPoint, listening, reading along. And also, as the expert witness, you can then kind of read your PowerPoint in front of the jury instead of having to memorize all the points that you wanted to make. So it also helps the witnesses be a little bit more at ease. When they don't have to remember everything they were going to say, they can just kind of list it off presentation. One thing in Wisconsin, which I'm assuming is the case everywhere, is that an expert should never vouch for the credibility of the victim. Should never say, I think this victim is telling the truth or not. That's something that's prohibited. Can't say that about any witness, about another witness. So that's something that you have to be very careful about. You can say this witness's behavior is consistent with what I've seen or with what I know or in my experience, what I've seen in my patients, but you can't say, I believe they're telling the truth. One of the things to also remember is, because you are an expert witness, it should be professional presentation. You are certainly going to be testifying on behalf of one side or the other, but try to be the most you can non-biased, honest, non-defensive about questions by the other attorney. And as Kirsten was saying, no diagnosis or ultimate opinion. That's usually not the role of the expert witness. It's more about explaining what the dynamics are. And so some tips for testifying, and these are tips that usually work for every witness, not just experts, but people just remember to tell the truth. It sounds simple, but sometimes people get tripped up trying to think, my answer might sound bad, or I don't want to say that because it might hurt our case. 9 times out of 10, the right course of action is just answer the question as honestly as you possibly can. It's the attorney's job to figure out how that fits into the case, and hopefully you will prepare it ahead of time to know what these answers are going to be. But when you're being questioned by the attorneys or the defense, just always remember the only job there is to tell the truth the best that you know it. Another thing that helps all witnesses and victims as well, but also expert witnesses, is to talk to the jury, not the attorney asking you the questions. If I'm the attorney asking questions, I already know the answers. I'm trying to give you the softball so you can turn to the jury and give them the explanations. If it's the defense attorney or the other side's attorney, usually it's defense. If it's the other side's attorney asking the questions, you're not there to convince them of anything. Even if you did, they wouldn't be able to admit it. So you're turning to the jury and saying, this is my answer to that question. They're the decision makers, is not the attorney. So it helps to remember to not get into an argument or in a battle with the attorneys. You're just there to educate the jury. Try to remember to use very basic language, avoiding any acronyms or abbreviations for maybe the places you work at or terms you use in your own internal systems. And I know it's easier said than done, but to not get angry or defensive at questioning. The one exception I might say is if somebody attacks you personally, like personally just saying it's okay to stand up for yourself, but to not get angry at people that are asking you questions. So a basic order of any direct exam is to explain to the jury the context of the domestic abuse or the sexual assault, what it is, what the dynamics are, explaining the impact of that assault on the victim, what happens to victims when they go through this, and then explaining the problem behaviors like we listed before, victim recantation, staying with the abuser, delayed reporting, and then explaining why that's normal or expected or whatever one word you use, but why that's not usually a problem in our areas of work. And then comparing that to this particular victim's behavior and how it fits in with the general knowledge of cases in this area. A good way of presenting it is to present how many victims you've seen of this type. You know, I've talked to 200 victims of sexual assault. And out of those, I've only had 3 that reported immediately to the police. The rest had some delay, at least a couple hours, if not days, if not years, to just try to explain to the jury how this dynamic fits into your general knowledge. One of the things that everybody always wants to know about and usually worries about is a cross-examination. And as Kirsten was saying, a very important point, this has to be prepared. As prosecutors, I train them, don't just tell your expert, here's what we're saying on direct, and then feed them to the wolves. Prepare for cross-examination, go over what the defense is, explain some strategies for responding to the other side's questioning. You should prepare for this. And then during the trial, the prosecutor should be ready with objections to protect the witness. And as a witness, you should remember to try to talk slow enough to allow for that. When a question is asked, just a half-second pause to gather yourself, make sure you understand it, and that gives time for the attorney to jump in with an objection. Another mistake some people make is to make sure you're listening to the question being asked and make sure the question doesn't have a false premise or something hidden in it that they're trying to get you to agree to. A common way that this happens is attorneys will ask compound questions, sometimes on purpose, sometimes just because it's an inartful way of asking a question. But they ask a compound question that has 2 or 3 thoughts to it. If you only answer one of those, sometimes you're implying the other 2 are accurate. And so just make sure you can understand the question being asked. It's okay as a witness to ask for clarification. Nobody should have to testify about something they don't understand. So if the question's asked in a way that you don't understand or needs to be explained, it's perfectly allowable to say, I don't understand your question. Can you please repeat that? I'm not sure what you mean by this term or that term. And that's definitely okay. And also remember that the expert's job is to convince the jury, not the attorney. Sometimes people get into a yelling match with the attorney, trying to get them to understand something, but like I said, they're not going to admit it, even if they do, and that's a losing battle. Your job is to explain to the jury why they should believe your side. Something I wanted to spend a little bit of time on is the problem that most people get into on cross-examination is this inherent problem where everything becomes consistent with being the victim. You testify that it's not unusual or it's normal for victims to delay reporting to police. Sometimes they take hours or days to gather their thoughts. They've been through something traumatic. It takes them a while to gather the courage to go to the police to report the incident for a whole host of reasons. The defense during cross-examination asks, it's correct then that some victims wait before reporting and that's consistent with being sexually assaulted, yes. If a victim reported right away a sexual assault that's also consistent with being sexually assaulted, yes. Well, that's an easy trap, and that's going to happen if you do this long enough that people will point out that whatever you're saying is normal or expected, the opposite is also possible. And the best way around that is that you're not really saying that anything is consistent or not consistent. It's just in your experience you don't normally see that happen. I had a sexual assault expert testify that she had seen 200 known victims of sexual assault in therapy. In her experience, only one had actually physically fought back with the accuser. Now, that's not to say it can't happen or it doesn't happen or it's not possible, but it's not what we see. And again, going back to where I started, you're just trying to tell the jury that if they're thinking that this didn't happen because of some myth, you're just trying to give them some context to say, that's actually not that weird for us. We see that all the time. A sane nurse can say, we see sexual assaults that don't have injuries all the time, and there are reasons for that. So very, very few of them have physical injuries. Rape crisis counselor can say, we all the time talk to women who do not say no and don't fight back, and there's reasons for that. Not to say that that means it happened or that it can't happen the other way, but just that when we see this type of assault, it's normal for us to see these symptoms. Kirsten was talking about strangulation. It's not normal to see bruises or marks of strangulation, but the defense would argue that if you were really strangled, you'd see a bruise. And we're just up there to say, well, you might, but if you don't, it doesn't necessarily mean that it didn't happen. And that's the point that you're trying to get across. But just be careful of this argument that everything becomes consistent with a victim, and you're just there to explain away any bad behavior, and your testimony doesn't mean anything. So again, what the expert advocate wants are protection from egregious cross-examination. And as I said, the softballs that set the stage for teaching the jury. What you should tell the prosecutor you want or the attorney that you want when you're working with them is, here's a question I want you to ask me, and here's the answer I will give to that. But you have to ask me the question in the right way and make sure the prosecutor or the attorney is using the right terms and the right language so that you don't have to spend time correcting them in the middle of the direct exam. You want to be able to say, these are the things that I can give you, but you have to give me the questions that lead me to that answer. And respect, I think, for each other's time. Both parties in this will be busy, but if it's going to be a workable relationship, you have to respect the fact that an expert will need time before trial to get prepared. You can't just give police reports and case information the week before and say, please testify for me. Or, God forbid, what Kirsten said, someone just sent a subpoena without any preparation. That should never happen. And the opposite is true, too, that if you're going to be an expert, you can't wait until the last second to get back to the prosecutor with the answers or with the information that they need, the exhibits. Those things have to be done ahead of time. And then, of course, any reimbursement for expenses is to be expected. Hopefully, you can work out agreements with people if you're doing prosecution cases that you don't have to spend a lot of money. We've been lucky in lacrosse to find people to volunteer basically to do this. They're either paid by their agency or they're just doing it free of charge, and we've been lucky in that way. I know not everybody has that ability. And then what the attorney wants is obviously somebody prepared, somebody professional, and an effective presentation that fits into the overall strategy of the case. And this takes time. This is something that needs to be prepared ahead of time. It's not something that just happens. If you're going to use a PowerPoint, I would always send the expert the PowerPoint ahead of time to make sure, again, the language is right, the wording is right, they're comfortable with the language that's being used. If you're using photos or exhibits, you have to go over that ahead of time to make sure that, again, the presentation to the jury is effective and professional and convincing and not just thrown together at the last second. One other thing that's not in here would be if you're going to use an expert witness, or if you're going to be an expert witness, you're going to be used more than one time. And I tell prosecutors to not overuse people. If I send Kirsten subpoenas for all my domestic abuse trials for the rest of the year, there would be about 30 of them. We can't expect people to set aside that many days when they're otherwise doing other work and vacations and conferences and everything else, and then have them be moved around and canceled the last second. And then just the opposite. Don't promise all your time to people if you really can't give them all that time. Both sides need to be upfront about how this is going to work, how this relationship is going to work, how often we're going to testify, how much we're going to get paid, how much time it's going to take, and you can't overuse the experts, and the experts can't overpromise to the prosecutors or the attorneys. And we finished early, but I was seeing some of the questions that were in the chat as Kirsten was talking. I think we're going to have some questions that will lead to a lot more time. So if you want to throw questions, we can go on from there.
I have a few more things about at trial that I'd like before we get to questions. Okay. I do want to just repeat the idea that you leave your big earrings and your purple ribbons at home and you present in a professional manner. And also, if you think about what you are best at as an advocate, if you are a good teacher, whether that's one-on-one with a client or if you're somebody who gets up in your agency and trains volunteers or you go out and you train the public, that's what you need to bring to it. So you need to be able to teach and train the judge or the jury. They're your audience. It may only be an audience of one, but I think it's reasonable for a prosecutor to expect you to be able to do that, have good presentation skills, and in many cases it might be phrased a little bit differently. You're still answering the same questions that you always answer in domestic abuse presentations. You're still going to have to answer the question often about whether or not it's just plain old mutual violence. And so you're still going to have to answer the why does she stay. You are very experienced as advocates of giving that, and hone it down, make it a nice, short, concise blurb, and if you want, practice. Tell the attorney you're working with, if you ask me this question, this is exactly what I will say. Sometimes I've even written those out and sent them so that they had a very clear picture of what exactly the context was that I was going to lay out. The cross-examination, really deposition is much more loosey-goosey than the actual trial itself. And I would say cross-examination, by and large, answer the question, answer it honestly, answer it fully, don't push it one way or another, and if possible, just agree and shut up, except for the questions that are all about, is it possible that? And I do think you need to be prepared to say things like, I don't normally see that, yes, it's possible, but it's not probable, or I would be surprised if a victim did that because it's not typical. But otherwise, agree and shut up if that's possible, so that you're not hanging yourself with too much rope. I think that, as I'm looking at my notes for myself, I think that's about it. Let's go to questions. Those are always more interesting.
Great. Thank you so much, Tim and Kirsten. We did get a lot of great questions to come in, so let's try to get to as many as we can. So one of the early ones that came in is, and I think this is a great question for both of you, is how do you negotiate the preferences of the survivor in deciding whether and how to use expert testimony in a case?
I'll go first because that is something that I always tell victims what the trial is going to be about and what evidence we're going to have. So I would explain to them why we might be using an expert, and most of the time it makes perfect sense because, as I said, a victim might say, I don't know why I didn't scream. I felt like I was screaming, but it was like in a dream and I couldn't get it out. And we will tell the victim that's not unusual. Many people feel that way. Usually there's an advocate with them that will say that's normal. But for the trial, instead of having you explain why you didn't scream because you really don't know and can't explain it, we're going to have an expert witness who deals with this type of trauma to come in and tell the jury why that might have happened and what the biology is behind the trauma. In domestic abuse cases, many times the victim will say they went back to their abuser because they loved him, and we will introduce an expert to just talk about why that might happen. And again, the victim is, in my experience, always been okay with it. If for some reason they weren't, I guess I might feel differently, but they've always been okay. They've always understood that it was a good idea, that it was helpful, that it's not on them to explain the reasons and the psychology behind their behavior. The expert's going to do that. That's my answer.
Well, Tim, how about if the survivor in the case just plain old doesn't want the case to go forward, and that's why you're using an expert?
So like in a domestic violence case, yes.
Yeah.
Those are cases where, we're not going to have the victim's consent in that case. If it's a serious enough domestic case where we're going to go forward, even though the victim is saying, I don't want to go forward, I'll still explain that to her. I'll still try to get to understand what we're trying to do. And again, in my experience, it really hasn't never been a point of contention. Even if they're adamant that they say, I don't want this trial to go forward, if we're able to explain it to them in a way of, we understand that, here's why we're going forward, here's why we're doing what we're doing, respect your wishes, but we're doing our jobs here. I've never had a problem in terms of them getting upset about the expert part. They're usually just frustrated that it's going forward at all. But the expert piece then really hasn't been an issue. And in those cases is where I would not really use the expert talking about their behavior. That's where I would just use an expert to talk about domestic abuse dynamics in general. And that might be how I would do that.
Oh, thank you. Kirsten, did you want to add anything?
Sure. I think that particularly in that last example, that's a really good reason why I don't necessarily believe you should be an expert witness within your own service area, or at least in that particular case. I think let me back up a second. If you're an advocate and this is somebody who is in your service area as a client or a potential client, I think there's a big risk there of you mixing your hats up. And that it's nice to have reciprocal relationships with advocates from outside your service area so that you can interact with that victim as an advocate and have somebody else be the expert. So you're not jeopardizing them using your agency's services in the future, or if they're using them currently. So, if it was a criminal case and this victim really truly did not want it to go forward, didn't want an expert to be brought in, et cetera, for myself, there's a real good chance that I would still take the case and say, yes, I'm willing to testify as an expert. But because I'm at a coalition and not at the local level, I would not do that if that was a victim that was in my service area for my program at the local level. Because of that hat thing.
That's a good point, Kirsten. I didn't go into that in this presentation, but we always use experts that don't have any connection to the particular victim, so there isn't a risk of them, as an advocate for that victim, potentially talking about that victim or perhaps opening the door to things that happened in the past or services in the past. We always make sure to get somebody who could have no connection to that particular victim. That's a good point.
Yeah, exactly. And if it's a civil case, and then not only is it that I'm being brought in often because the victim wants me, but sometimes it is actually the victim calling me and saying, I have X, Y, and Z case, and can you help me? And they may be calling to say, can you help me to talk to my attorney, or can you help me, my attorney says that, this is going to be an issue, so I was wondering, in that case, there isn't a conflict in that the victim obviously wants me. Where the conflict potentially is there is I want to spend as little time possible talking to that victim, and I will shut down that conversation as quickly as possible and say, I need to talk to your attorney. And explain, I don't want to set up any kind of relationship with you, counseling relationship, an advocacy relationship, etc. I need to go through your attorney and see if there is something that I can help you with for the case. So that's my response to that kind of question. I think that there's a role for experts to take kind of like we have attempted to do with mandatory arrest, to take the responsibility for being the bad guy, just like prosecutors do. I think experts in some cases in criminal take that responsibility off for being the bad guy off the victim and are, in a way, able to be that victim's voice in the court. And there is a role there, even if that particular person is saying, I don't want this case to go forward, because so often you don't know what they really want. Are they being pressured to say they don't want it to go forward? Do they really not want it to go forward? And so having a completely disconnected, separate expert, I think there's a role for that.
Thank you. Another question we got pretty early on is how, in a prosecution case, do defense attorneys go about challenging the expertise of your expert, and what do you do to prepare for those challenges?
Like Kristen was saying before, we stay away from research as testimony for the reasons she mentioned, but also just because it's kind of lost in the jury when you start talking about studies and percentages, and every study has a reverse study somewhere. And so in our cases, what we've done is just use people who have been doing it for long enough that there really isn't much to question. If somebody's been working with domestic abuse or sexual assault victims for 20 years, that pretty much ends it. We're lucky enough to have that in our community where we've got people who are doing it long enough and seen enough people that there really isn't much room to say that they don't know the area or don't know what their level of expertise is. And it's also sometimes impressive for the jurors to hear how many people they have seen, because jurors generally don't know how much there is in their community. So when they hear that they've seen that many women who have been victims, that's kind of an eye-opener. And that's kind of ended the possibility of them challenging their expertise. We tend to use people who have experience versus like research credentials. In our experience, that's been better, again, to give the jury the real life, this is how many victims I've dealt with and this is what I've seen. And it doesn't so much matter what their degree is or what their education is. I know some other jurisdictions have want to focus more on people who have like a PhD or a master's level. We're lucky enough in Wisconsin that we just need experience to be an expert. It could be anybody who works at a rape crisis center, anybody who's seen enough victims, and so we don't have to delve into too much educational background or research background.
And I'd say ditto. I stay away from the research. I talk about my own experience. One time I was asked if I had any advanced degrees, and, no, you have in front of you, no. One time I was asked what on earth, because my bachelor's is in anthropology, I was asked what on earth anthropology had to do with domestic violence. And I was like, well, it would be the study of human behavior and culture. It has everything to do with domestic violence. So it really hasn't been challenged because I'm talking from what I know from actually working with survivors.
That response leads really naturally into another one of the questions that we got, and I think you've both partially answered it. But in terms of credentials for expert witnesses, can you talk about situations where advocates might be exactly who you're looking for as opposed to scholars or researchers, or are there cases where the opposite is true? Like how do you make that determination about the background that you want your expert to have when you call somebody to the stand?
Well, we had a judge early on when we started trying to do this ask, how can somebody be an expert on a topic if they don't have a PhD or some other degree? And I said, if I wanted an expert on how drunks behave, I call a bartender. It doesn't matter what degree they have. Who knows more about it than somebody who's there every night? If I want to know about sexual assault victims, who knows better how they behave and the reasons why they behave that way than somebody who deals with them every day? Now, researchers might also know about it, but in many cases, I think the people that are on the front lines know more about it than the people that are doing the research. So we've gotten pretty easily into not needing the credentials. Now, if you're in a jurisdiction that requires it, I guess you have to go that way. But in Wisconsin, we've seen it either experience or education or research, and I think the experience is the more impactful for the judge and for the jury. And so that's how we've gotten to that point.
Got it. Thank you. And so just kind of to piggyback on that, there was a question about how you get courts to accept testimony from advocates who don't have a PhD. I think, Tim, what you said is really important. Just make sure that the attorney who's proffering the information goes to the statute, because I think in most states, there's not a bright line rule about what kind of degree you have to have, and experience counts for expertise.
Yeah, that's my understanding. That's how I would approach it.
Yeah. So, just because courts aren't maybe used to seeing people from experiential background doesn't mean that they're not to be admitted. There was a question about forming relationships. Basically, how a domestic, what are some strategies for a domestic violence or sexual assault agency to approach the prosecutor's office to form partnerships around providing expert testimony? I think the question was for all the presenters, but if you two, all the participants, but if you two have any wisdom to share on this, it'd be helpful, how you've seen these relationships happen.
In our jurisdiction, we've got a coordinated community response. I think it goes by different names in different jurisdictions, but task force or community response team or whatever the name goes by, but same nurses, prosecutors, police, advocates, all getting together to try to get on the same page. We have that here. And so for me, it was just natural when I needed to reach out to an expert. I knew people on that committee that had been doing it for decades, and they knew other people that I didn't know that have been, doing this work for a long time that I could go to and say, I'm looking for people to be expert witnesses. We also sent around a questionnaire to the local hospitals and counseling centers, just kind of asking basic questions. Do you counsel survivors or victims? If so, would you be willing to be an expert witness? And we got a list of people that were willing to do it. Some said they could only do it maybe once a year. Other people said they could do it as needed. Other people said they'd like to, but they would want to get training. And so that's how we did it.
Thank you. One of our participants just clarified that in terms of getting challenged by the defense attorney, she wasn't necessarily asking about credentials, but more about strategy on cross-examination. And so are there particular challenges that you see over and over again from defense attorneys, and which are the biggest?
Over and over again, I see that isn't it true that you haven't actually, you have no personal knowledge of this defendant? Yes. Isn't it true that, you didn't personally witness any of, they're basically trying to say that because I am not a fact witness, that I really don't have anything relevant to say to the case. And so those are good examples of where, by and large, you would just say yes and shut up. Yes, I was not there. Yes, I have not met the defendant. Yes, I've not had any conversation with the victim. And leave it at that, because that's simply true. That happens constantly. Isn't it true that that it could in fact be mutual violence is very common, and so that is partly it's hard because it really kind of depends on how they're asking the question. So part of the answer to that is often talking about primary aggressor, and part of the answer to that question is going back to the it's unlikely that, or it is, in my experience, it has been to clarify, no, the most common scenario is not mutual combatants. those are really common. I'm trying to think. Fear, again, fear being, isn't it? It's unreasonable that this person was afraid and they responded crazy to this defendant when all the defendant really wanted was to return the mittens or whatever else. So being able to talk about fear, and that fear, well, sometimes actually, I'll tell you what, sometimes I pull out Mark Twain, and Mark Twain said that a cat that sits on a hot stove will never sit on a hot stove again, but it'll never sit on a cold stove either. So that victim can only base what they know on their previous experience of this defendant. And so it is reasonable for them to think that they might be in danger. But that is how victims in general make that decision, just how we all in general make our decisions based on our previous experience of a person, a cat, a stove, a shopkeeper, you name it. I think it's just really important not to take the questions personally, to slow down and take a drink of water and make sure you have some water up there because that gives you time to think, and to treat it as any other training participant that you've ever had asking you a question.
Thank you.
And I think the one thing that I see over and over again is people asking, is it possible? And like Kirsten said, sometimes, yeah, you have to just agree, is it possible that this sexual assault was consensual, or this intercourse was consensual? Yeah, anything's possible. And some people will just go through a list of is it possibles, and many times the answer will be yes. Now, they might have something that is not probable, and you can come up with different ways of saying, well, it's possible but not probable, or it's possible but I don't see that very often, or it's possible the sun might not come up tomorrow, but probably it will. So there's always things you can say if it gets a little ridiculous, but they will ask questions about other possibilities that you have to acknowledge. And again, that's not why you're there either.
Thank you. Kirsten, this has come up a couple different times in the chat. People are really interested in hearing more about how you use the lethality assessment in court during your testimony. Can you talk about how that gets woven in?
Sure. I'll give a couple examples. What I have done is I have gone through just the case file myself and scored it just from what is there. In a couple custody cases I did this, and basically said this is a tool that exists that is well researched, that I'm very familiar with, and I can talk it up one side down and down the other, and just scoring the materials I had, or just scoring the deposition. This person scored a 10, and according to this particular tool, this is what the 10 is supposed to mean. So in terms of saying whether or not, again, it was reasonable for the person to be afraid, or just to give an idea of the level of abuse. In a custody case, I've done that twice. I did that in a case that was it was sentencing. Actually, I was pulled in at the sentencing phase, and we haven't even talked about that as a possibility as an expert. But that is also true. That's when I got introduced to the case where it was a battered woman who had pled guilty to participating. It was a big federal drug case. But her attorney was pulling me in to basically say she was battered, and can you talk about coercion? And so I was able to use that to say, again, when I score just the facts of this case, she has the highest possible score you can get. So it may be possible, based on that there is, some other way of saying that she was under she experienced some kind of threat or coercion when she engaged in the drug stuff that she was doing.
it sounds like there's really unique circumstances where you can talk about a specific score on a specific test. Is that fair to say?
Yes, exactly. I have never used it in a criminal case, and I simply wouldn't, to go in and say, well, clearly because he scored a 7 or whatever that he must have been the one to do this. I don't think it's really appropriate in that kind of circumstance. But to give some kind of credence or some kind of power to how that person might have been afraid and the level of risk they were under when they did something that seems kind of wonky, it has been helpful there. And it has been helpful for me in talking to attorneys to explain, again, that education piece, to say, well, I can tell you why she's doing that. and then to use that, it's, some people like to have a separate tool and some people like to have numbers. So to say, well, I just for my own opinion, and even when I'm preparing a case, I will often have the power and control. Well, I don't have the wheel in front of me, but I've got the stupid thing memorized. And when I go through, I'm looking for those specific tactics, and I'm outlining what is in the case there as a way just for me to organize the material. And then I also use the danger assessment as a way for me to organize the material. And then I can use that as a framework when I'm talking to the attorney. Here's why this victim is not cooperating. This is the level of fear that they're under. So it's been useful for me that way too.
That's really helpful. Thank you.
Yep.
Checking the time, I see that we have about 2 minutes left. So at this time, Sue, I'm wondering if you have anything you want to add, and whether our presenters have any last words of wisdom they'd like to send us away with.
This is Sue Osthoff. I just really want to thank all of you. What a terrific presentation. And I think you whetted the appetite of a lot of our participants, and I hope we can continue talking with you guys. So this is incredibly helpful. Thank you.
Tim or Kirsten?
I would just say good luck. It's not easy working with attorneys. I know that. Train them well.
I would say that this is important work, but it's also the one part of my job that still gives me anxiety and I still fret about. And if you are going to engage in this work, I would ask that people do it thoughtfully, not only on a personal level, but since most of the participants are advocates, to do it on a state level. One of the things that the Iowa Coalition has done is to provide trainings for advocates on how to do this. We've done mock trials so that people could try out how it feels, sit there in the stand and try to answer questions, and have asked some of our ally attorneys to come and participate in that. We have partnered with the Attorney General's office and with the Bar Association and with our local, our low-income Iowa Legal Services to do trainings for, like, mutual trainings between both advocates and attorneys, so that the attorneys are learning this materials of, how could I use an advocate in my cases, to both get the word out and to begin to build those relationships, and also to make it clear what the expectations should be. So I think, it might be one thing to say, I'm going to go and do this myself. I would also ask that you do some of the coalition building and ally work to think about it in a more broad statewide perspective.
Great. Thank you for that, Kirsten. Thanks, Kirsten and Tim and Sue and Dot, and to everyone who was able to be on this webinar with us today. I think we all learned a lot, and for the questions we did not get to, we'll do our best to try to get you some answers, okay? Thank you so much, everybody.
Thank you.
Thank you.